Assalamualaikum and greetings to Madam Afsan. Thank you for taking the time to watch this video presentation. Today, our team will present about the court case of Chan Yeong and Gamuda Land T12 Sendirian Berhad. Before we start, let me introduce our team members, which is NISHA Saffeya binti Azmi MURAD, SITI SAHIRA binti Abdul Halim, ATIKAH binti Muhammad NAZRI, and Izzmi Azmira binti IZZALEE. Without further ado, let's start with our first presenter.
The case of Chan Yeong versus Gamuda Land T12 Sendirian Berhad involved a dispute over constructive dismissals. Chan Yeong, who began working as a secretary with a Gamuda subsidiary in 2012, was later transferred to Gamuda Land T12 Sendirian Berhad. In 2018, she was reassigned to the Gamuda Cove project in Dengkil, requiring a daily commute of 60 to 70 km from her home in Rawang. Chan objected to the transfer because of citing financial burden, safety concerns, and significant changes to her job scope, which she perceived as a demotion. When she unable to resolve this issue, she resigned in April 2019, claiming that her resignation was forced due to her employer actions. The company defended its decision, stating that the transfer was standard practice in project-based roles and was allowed under Chan's employment contract. They offer a salary adjustment to offset the increased travel costs and explore alternative roles, but Chan declined this option. The company also argued that her resignation was voluntary as she had sought a new job prior to leaving.
Now, I will be presenting about the chronology of issues in the case of Chan Yeong and Gamuda Land T12 Sendirian Berhad. First, let's start with the employment history. The claimant Chan Yeong joined Valencia Development Sendirian Berhad on 3 December 2012 and was later transferred to other entities within the Gamuda Group, which is a project-based company. Next, for the transfer announcement, on 26 July 2018, she was informed of a transfer to Gamuda Cove in Dengkil effective 1 August 2018. However, there was an objection to the transfer. On 31 July 2018, the claimant raised concerns about the long commute from Rawang to Dengkil, which was 60 to 70 km daily, and the insufficient travel allowance of 200 ringgit. Following the transfer, there was a change in her job scope. Her responsibility shifted from secretary duties to tasks involving sales, marketing, and asset management, which she found overwhelming and difficult to manage. Eventually, this led to her resignation. On 16 April 2019, she resigned, citing dissatisfaction with the transfer and job changes, claiming constructive dismissal. Finally, for the court decision, on 2 November 2020, the industrial court ruled that the transfer was within the company's right under her employment contract. The court dismissed her claim of constructive dismissal, concluding that she resigned voluntarily. That's all from me. Thank you.
Now, I will be presenting about the causes and effects of the case Chan Yeong and Gamuda Land T12 Sendirian Berhad. Firstly, the causes are workload concerns. The claimant who worked as a secretary found her workload too demanding. Next, she was transferred to a new role and location. She was informed that she had to move to the company's site office in Dengkil, which was quite far from her residence in Rawang. This has increased her daily commute to around 60 to 70 km, which she argued has caused undue hardship. On top of that, her job functions changed. She was now responsible for sales coordination, personal requisition, and acting as a fixed asset representative, tasks that were not originally part of her job scope. Furthermore, the claimant felt that the company did not properly consult or consider her well-being before making all these changes. And while the company offered the 200 salary adjustment to compensate for the longer commute, she found that it is insufficient to cover her additional expenses. Next, we move to the effects. Due to these factors, the claimant decided to resign. She submitted her resignation, claiming that she was constructively dismissed, meaning she believed the company's actions had breached the terms of her job employment. She then brought her case to the industrial court, arguing that the transfer, change in job scope, and lack of adequate support has made it impossible for her to continue working.
Assalamualaikum and welcome. Today I am going to dive into the case of Chan Yeong versus Gamuda Land Sendirian Berhad and understanding the concept of constructive dismissal under Malaysia's Industrial Relations Act 1967. In this case, Chan Yeong claimed constructive dismissal after being transferred by her employer to a site office far from her residence. She argued that the transfer caused undue hardship and amounted to a breach of her employment contract. Section 20 of the IRA 1967 allows employees to file a claim if they believe they were dismissed without just cause or excuse. Constructive dismissal happens when an employer's action forces an employee to resign by fundamentally breaching the terms of their contract. The court emphasized that employers have the right to transfer employees within the terms of their contracts. Chan had agreed to a transfer clause when she joined, which allowed the company to reassign her to different locations, including internationally. Ultimately, the court found no evidence of bad faith or malice by the employer. While the transfer caused inconvenience, it didn't breach the employment contract. The court ruled Chan's resignation was voluntary and dismissed her claim of constructive dismissal.